Well, good afternoon, everyone. My name is Douglas Grimm, and I'm a partner in the law firm of Arent Fox in Washington, D.C. And I'm speaking to you today about fraud and abuse in healthcare and the vivid title of What to Expect When the Government Comes Knocking. This is an area of focus for me, compliance and fraud and abuse. I've been in healthcare for about 30 years now, both on the operations side, the provider side, and for the last 15 years or so on the legal side. As I said, my focus, one of the focuses of my practice is fraud and abuse. I also focus on reimbursement and am the firm's primary contact for telemedicine. So this is an area of great interest and one that our clients are constantly in contact with us about as the landscape changes so quickly, particularly due to COVID. So we're going to move relatively quickly through the legal landscape, and then we're going to get to some case studies that I think will help illustrate for you how the government views telehealth arrangements and what is okay and what is not okay. So first, we're going to talk about the government agencies that get involved. Again, we'll do a brief overview of fraud and abuse laws. I had the privilege of speaking to you last year and spent a pretty significant amount of time on the laws, which, we then had to rush a little bit on the end regarding the case studies. So I'm going to try and reverse that and move quickly on the laws. Spend some significant time on the case studies, hopefully, and then give you some advice and ideas on what you should expect if you or your company are contacted by a government agency, and then the strategies and preventive measures that you can employ. And actually, CMS and OIG provide a listing of elements of a compliance plan that I think will do you in good stead. So, to begin, who's who? Here are the government agencies that are primarily involved in the regulation and oversight of telemedicine. First, there's the Department of Justice. Second is the Federal Bureau of Investigation. Those folks are generally involved, for criminal matters. The FBI is. DOJ will handle both criminal and civil. And some of the laws that we're going to cover this afternoon are civil and some are criminal. The IRS may get involved, and then I'm sure you've heard of the OIG and CMS. And then the state Medicaid programs have fraud control units, and South Carolina is no exception. So those are the players. Those are the six kind of primary departments that you need to worry about when considering fraud and abuse issues. So there's three laws that I want to give you a brief overview of this afternoon. The first is the Stark Law. And many of you may be very familiar with this, but what the Stark Law does is it addresses squarely the relationships between physicians and the entities to which they refer. And that's it. It doesn't apply to DME providers. It doesn't apply to, well, actually, in some cases it can. Come to think of it, we're going to cover some of that in the case studies, but it generally covers hospitals, telehealth, telemedicine companies, and the physicians. And it says if a physician has a financial relationship with that entity, then the physician cannot refer patients to that entity. And that is a strict rule. That is it. A physician cannot refer if there's a financial relationship. However, for every rule, there are exceptions. And if the exceptions are met, for that, all of the elements of the exception are met, then it is okay for the physician to refer patients to that entity. So what are the common exceptions in telemedicine? Employment. So telemedicine company may employ a physician, a hospital may employ a physician. for which that physician may be then referring patients. But the employment exception contains certain elements, all of which must be met. You can see below there the exceptions generally require a written and signed agreement, that they be commercially reasonable, and the compensation be at fair market value, and it does not reflect the volume or value of referrals. So to put that into English, for an agreement to be commercially reasonable, it must be for engaging the physician for telemedicine services. It can't be for engaging the physician for lawn services or for marketing services that have nothing to do with the hospital, right? So it has to be an agreement that passes the reasonableness test. When it says that compensation does not reflect the volume or value of referrals, that just means that the agreement can't say, well, if you send me 5 patients, I'll pay you $100 a patient, but for patients 6 through 10, I'll pay you $200 a patient. You know, that would violate these exceptions to the Stark Law. So there's employment, there's personal services, which generally would be your independent contractor relationships, space and equipment leases, where the hospital or the telemedicine provider is renting audio-visual equipment or office space to the physician. Those rental agreements, again, must be in writing, commercially reasonable, and fair market value, and so on. Same too for electronic health record systems and equipment. So that's the Stark Law. Again, applies to relationships between physicians and the entities to which physicians refer. The Anti-Kickback Statute is a criminal statute, and it applies to everybody, not just physicians and the entities to which they refer, but to everybody, including everyone on this WebEx. And what the Anti-Kickback Statute does is it prohibits the payment of remuneration to another party to induce or reward patient referrals. And those referrals would then be payable by a federal healthcare program. States may have their own, and virtually all of them do, have their own anti-kickback statutes that would apply to Medicaid referrals. And some states have all-payer statutes, which would include commercial plans as well. So the law applies to both sides of the agreement, both offerors and recipients. Now, the Stark statute is a strict liability statute, and what that means is it doesn't matter what you were thinking when you crafted the arrangement. If you don't meet all the elements of the exception, then the law is violated. The Anti-Kickback Statute looks to intent. What did you mean to do? If one purpose is to induce referrals, then it's violated. Okay, but if you show that the agreement was made in good faith, even though it may not meet all of the elements of what we call safe harbors, then you're okay. So the Stark Law has exceptions. The Anti-Kickback Statute has safe harbors, but for our purposes, they're essentially the same thing. But then what is remuneration, right? It's not just cash. It could be payment above fair market value. It could be giving free equipment or rent, provision of office assistance, and then hotel stays and so on. Now, the Stark Law and the Anti-Kickback Statute, if violated, may lead to False Claims Act liabilities. And this is the behemoth in federal healthcare law, as you may know. This is where not only are you assessed fines and penalties under Stark and or the Anti-Kickback Statute, and it's possible to violate both at the same time, but also then you're assessed monetary penalties on a per claim basis, and then those amounts are trebled. Well, actually the amounts that are billed in violations of the law are trebled and or up to trebled. And that is can be just a devastating amount to any entity. You also can be excluded from federal healthcare programs. If it's an individual that's involved, there may be sanctions or loss of professional license. And if you're an entity that's accredited or certified, then you're at risk there, right? Because these proceedings are public. Even if you settle with the government, those settlement agreements are posted online. So, and the accrediting agencies probably require you to make a report to them of any settlement or other discussions with the government regarding your activities in the telemedicine realm. Another note on safe harbors, remember it's an intent-based statute, no liability if all of the elements are met, right? But you don't have to meet all of the elements. Under the Stark statute, you do have to meet all of the elements of an exception. But under the Anti-Kickback Statute, you do not. If you do, you have proverbially sailed into the safe harbor and you're completely immune. If you only check 3 of the 4 boxes, you're not immune, but then you look to your intent. And if it was in good faith, then the government may still determine that while you didn't meet all of the elements of the safe harbor, the agreement is still okay under law. So, and that's where you see the third bullet. The closer you get to satisfying all of the requirements of a safe harbor, then the safer the arrangement is. And the safe harbors are essentially the same, again, for our purposes as for Stark. Employment, personal services, space or equipment leases. And sure enough, the common requirements for safe harbors are very similar to Stark. Now, as we're going to get to, considering the rapid expansion of telemedicine reimbursement and services in the time of COVID, there is quite understandably some malfeasance on the part of some providers. I am certain it's not the case where anybody who's dialed in to this call, but in any event, in moving quickly to try and help your patients, your patient population, some of your arrangements with physicians or other entities may not fully meet the requirements of under Stark or the Anti-Kickback Statute. And CMS, which is the entity or the agency that enforces Stark, and OIG, the agency that enforces the Anti-Kickback Statute, have put forth policy statements and said that they will exercise enforcement discretion. So we read that in the legal community to mean they're going to give you the benefit of the doubt, provided that the arrangement must relate to one legitimate purpose under COVID, right? And that's going to be a high bar. You're going to have to show that. But they're going to be a little more lenient than they would in other situations. So let's move on to some of the case studies that are well, some of them are classic case studies, and some of them are quite recent and somewhat complex. So you're going to have to bear with us as we move through. And the first is Operation Brace Yourself, which is now about 18 months old, but it continues to reverberate throughout the industry as a very intense and meaningful prosecution by the government. And what it involved was a fraud scheme of over $1 billion that involved 5 telemedicine companies, DME companies, and other medical professionals. And generally it involved the providers partnering with practitioners and DME suppliers or pharmacies for the provision of goods. And so what you see with Operation Brace Yourself here is while the slide is busy, I'm going to walk you through from the top moving down. So let's start at the top with DME suppliers. And the DME supplier has determined that it wishes to grow its market share and sell more DME items. And so it engages a marketing company to identify prospective patients that would need the DME company's product, right? And in order for the marketing company to do that work for the DME supplier pays remuneration to the marketing company in the form of cash. And again, the marketing company then, as we're moving clockwise, the marketing company then identifies the patients and provides that patient list to the telehealth company. So the telehealth company is now sitting on a list of patients for which they may need DME. Well, the telehealth company needs physicians to prescribe that DME. And so the marketing company pays the telehealth company. The telehealth company then in turn engages a bank of physicians, right, which is your physician panels that everyone is well aware of. And those physicians are then paid to make referrals to the DME supplier. So the DME supplier pays the marketing company pays the telehealth company pays the physician then makes the referral to the DME supplier, and the DME supplier then bills the government for the supplies and provides the equipment to the patients. So it's kind of just a never-ending circle, right? And you can see how that involves the Anti-Kickback Statute, right? So there's the payment of remuneration for referrals that passes from one entity to the next, all of whom are well aware of the scheme that is underfoot. And so this was Operation Brace Yourself. And it defrauded the government out of over $1 billion. Truly a significant loss. And so, again, while it looks somewhat complex on the slide, it's relatively straightforward. The supplier hires a marketing company identifies patients, passes them on to a telehealth company who hires physicians. The physicians write the prescriptions for the patients, send the prescriptions to the DME supplier, and the DME supplier bills the government. And the government pays the DME supplier. So everybody gets paid. And that's not how it's supposed to work. So let's move on to example number 2, patient discounts. Here you have a telehealth company and you have patients. So the telehealth company is looking to grow its patient base. And so the telehealth company offers to waive copays or deductibles, or is considering waiver of copays or deductibles. And remember, waiver of amounts or reducing amounts is remuneration, right? It is an inducement, right? If the patient is looking at 2 telehealth companies, one of whom says, well, I'm going to charge you a copay and a deductible, and the other one says, I'm not, well, which one do you think the patient is going to go with, right? So that's remuneration. So that implicates the Anti-Kickback Statute. So the telehealth company is offering remuneration to the patients. And the patients, in turn, are then purchasing the services from the telehealth company that are reimbursable by federal healthcare programs. Now, remember, I said that one of the elements or one of the tests under the Anti-Kickback Statute is the intent of the parties. And although a safe harbor may not be met, you look to the intent of the relationship to determine culpability under the Anti-Kickback Statute. And so in this example, when determining whether or not it's okay to waive copays or deductibles, you have to look to the intent of the telehealth company. And actually, waiver of copays and deductibles routinely is prohibited by CMS and OIG. But it is permitted on a case-by-case basis. And it's subject to the ability of the patient to pay. And if they can demonstrate a true financial hardship, then the telehealth company may offer that waiver without implicating the anti-kickback statute. So this example number 2, is it okay? Well, it depends. If a discount is offered on an individual basis and the patient is truly unable to pay, then it's okay. But if the telehealth company is pulling a billboard on the side of Interstate 85 saying, hey, we'll waive copays and deductibles for you if you come to us and use our services, then that's not okay. Example number 3. So here you have physicians, manufacturers of supplies or equipment, and you have a hospital. So the manufacturer wants to grow its market share, a common theme here for this presentation. And so it goes to the physicians and offers the physicians free equipment and travel in exchange for the physician purchasing equipment from the manufacturer or going to a hospital or other physicians and recommending purchase of the manufacturer's equipment or supplies. The manufacturer then turns to the hospital and says, hey, these physicians over here are recommending that you purchase our equipment. Let us give you a demo or let us give you a presentation on that to encourage you to purchase our equipment. And if you do purchase our equipment, we're going to provide a sum of money in the form of a grant to assist in building a new wing of your hospital. So here you have remuneration and inducement going in all directions, right? The manufacturer is paying remuneration in the form of free equipment or travel. The physicians are accepting that, right? So remember, the anti-kickback statute applies to both the offerer and the recipient. So right there, you've got an anti-kickback statute issue. And then same with the hospital, right? It's kind of a quid pro quo, right? I'll buy the equipment if you give me the grant dollars, right? So we'll still look to the intent of the relationship, but this one is, more than likely would be viewed as an illegal inducement to purchase equipment, right? And you would see that in the telemedicine context frequently with folks who have they're unaware of the implications of the arrangements that they're entering into, but nevertheless, this is unfortunately a fairly common arrangement that we see, and then my clients or prospective clients call me up and say, here's the arrangement that I entered into. It's in writing, but we just want to double check with you and make sure it's okay. And I always say to them, I really wish you had checked with me before you did this. We'll help as best we can, but you want to be prospective in your analysis to the best of your abilities, and we'll get to that in just a moment or two. So what to expect if the government knocks on your door? Generally, the government's going to knock and seek information, and that information request is going to come in 2 forms. One is a civil investigative demand, and the other is a subpoena. Civil investigative demands are requests for information, which you just provide. Subpoenas are requests for information, but you must then swear that that information is correct and complete, right? So then you're faced with penalties if that information is not accurate and complete. Generally, you'll also be required to preserve all documents. You can't destroy documents that may relate to what the government is asking for. And your attorneys will more than likely enter into negotiations regarding the scope of the CID or subpoena. So the government's generally going to show up and say, well, we want all documents related to everything since the beginning of time, right? It's a very broad request. And so your attorneys would then work to narrow the scope. Look, the telehealth program's been in place for the last 3 years. Let's get it down to 3 years, not 10 years. And here are the physicians that were involved, that were employed by the hospital. Let's just have those employment agreements involved and not employment agreements for physicians throughout the entire hospital, right? So you're narrowing it and focusing it. You'll then undoubtedly conduct an internal investigation. And one would assume your compliance officer is doing that. And there are very specific guidelines and rules that may benefit you if that investigation involves counsel, your legal counsel. which it should just from a common sense point anyway, because your lawyers can point out to you the different laws at play. And then the process is ongoing, right? Some of the investigations I've been involved with have gone on for years. Some of them are resolved within 9 to 12 months. The government doesn't move quickly, and they move very deliberately, and they generally leave no stone unturned. So the process can be lengthy, and that may involve your attorneys making presentations to the government saying, okay, here's what happened, here's why it happened, here's the effect of what happened, and here's why we think there's no problem. And ultimately, with any luck, you move towards settlement, which may involve, and on several occasions, absolutely no admission of fault by the provider and no repayment of any amounts or fines or penalties. So those are the good results to get. And it's always a pleasure to call my clients up and tell them that's where we ended up. So in an event to avoid those investigations, let's talk a moment or two about preventive measure. Right? And I said it's always better for me to get the call on the front end, or your attorneys to get a call on the front end and say, hey, can you take a quick look at this agreement before you sign, right? And you want to analyze the arrangement. And I don't care whether you're the compliance officer or you're in the business office or you're the director of the telemedicine program. If you have the agreement available to you, take a look at it, right? And look, what does it involve? Who's paying under the agreement, right? Does it involve federal health care beneficiaries? Does it involve state law, Medicaid beneficiaries? Is the remuneration paid for legitimate services, right? So we've talked about the different types of services and what remuneration is, the exceptions to the Stark Law and the Anti-Kickback Statute. And I understand I only have 30 minutes here. I could speak on this for 3 hours, but you will be provided, or you will have available to you, a copy of this presentation after the fact. So if you want to go back and take a look at some of that material, you'll be able to. And then if you can, try and determine whether or not the arrangement fits within a safe harbor or an exception. I would advise you to do that with your counsel, but at first blush, you should do it yourself. One of the elements of the arrangement is, do the parties represent and warrant that this agreement is in compliance with all applicable federal health care laws and state laws, right? And then there's kind of the smell test. Is the arrangement too good to be true? Are you getting paid something for nothing? And you should make inquiries as to the payment of indirect kickbacks, such as what we saw under that the brace yourself slide, where you have 4 related entities, each of which is paying remuneration to each other. The OIG and CMS have put forth guidelines for effective compliance programs. And it's always good to have that compliance program in place and actively promoted to your employees so they're aware of it, what they can and they cannot do. Because the very first thing that the government asks is, do you have a compliance program and have you been following? Have you implemented it and have you been following? And CMS and the OIG tell you exactly what should be in that program. It's not limited to those elements, but nevertheless, they tell you. So writing it and putting it on the shelf is not good. Lots of folks do that. You need to implement it. You need to educate your employees about it. This is what the compliance officers do. If you don't have a compliance officer and you're responsible for your own compliance, then reach out to your attorneys. If you don't have attorneys, then give me a call and I'll point you in the right direction to where those compliance programs reside in the Federal Register. And of course, because we're all telemedicine providers or involved in the telemedicine space, those policies must take into account the unique nature of telemedicine services, right? Looking at the relationships between the parties. They're much more sophisticated than simply a doctor in a hospital, right? Make sure that you take a look at the policies and that they're keeping up with the law. Obviously, under COVID, telemedicine has exploded. But with that, so too does the potential for running off the rails or coloring outside the line. So you need to be careful and deliberate in your steps. And I know that's nothing that you don't already know, but when you're implementing a compliance program, it's something very helpful to keep in mind. And I say consult with legal counsel when appropriate. When you're drafting a compliance program, a compliance plan, and then implementing it and creating a program, I think an ounce of prevention is worth a pound of cure, right? I always tell my clients, look, getting you out of the jam is going to be much more painful, both in terms of impacts on your operations and legal fees, than it will be having your counsel look at it on the front end. right? So that is certainly a theme here of this presentation. If you have lawyers out there, that's what they're there for. They'll help you when you're down, but more importantly, they'll help you when you're contemplating entering into arrangements with third parties, whether they're physicians, whether they're hospitals, whether they're telemedicine companies, DME suppliers, you name it. That's what your lawyers are for. So I brought it home right on the 30th minute, I believe, which was the time allotted. My contact information is on the screen in front of you. Last year I received quite a few calls regarding the information that I presented, and I was happy to have those calls and give you additional information, answer your questions that came up. And I reiterate my offer this year. Feel free to reach out if you do have questions. I'll do my best to help you understand the laws. It wouldn't be legal advice, but it certainly will be some guidance. And I'm happy to do that. So thank you very much for your time. I appreciate this opportunity, and I hope you enjoy the rest of the summit.